Good morning and welcome to the 5th District Court of Appeal. Can everyone hear me? Great, thank you. We have today one case, Ryan versus State of Florida, 23-1479. We greatly appreciate counsel's indulgence in that we have set this twice now and are finally here to hear arguments from you. Speaking for myself, I think the focus for me at least will be on the second DCA case in Krose, K-R-O-S-E, which came out after the briefing in this case. That doesn't mean you can't argue whatever else you want to argue in the case. That's, I think, at least essential feature for me. I know that other judges on the call may have other perspectives as well. So I believe we have 20 minutes per side. When I preside in these kind of cases, if it gets to be a very fruitful discussion with lawyers, we're glad to go beyond that if there's questions from the judges that take us beyond the 20 minutes. So with that, you'll see that there is a timer. Now keep a close eye on it. The yellow and red kind of blend together sometimes, so it's hard to see, but keep a close eye on that. So if counsel, if you're both prepared, we will start with appellant.
May it please the court, co-counsel, my name is Darnell Lashy, and I represent the appellant in this case, Mr. Michael Ryan. And I would also like to, at this time, if I may, reserve 5 minutes for rebuttal.
Great, thank you.
The issue before the court today is whether Mr. Ryan was released from the sanction imposed in his underlying case, thereby triggering the registration requirements in section 9430435 Florida statutes. In December of 2018, Mr. Ryan was charged with 1 count of sexual offender failure to notify driver's license office of change in residence. In March of 2022, Mr. Ryan filed a sworn motion to dismiss, in which he argued he did not qualify for current registration requirements under section 943.
Counsel, on that sworn motion, even if the fact of the outstanding fine and costs is deemed admitted, don't we still have to determine whether that fact is material? In other words, whose statutory interpretation is correct?
I believe that based on the clear and unambiguous language, Your Honor, of the pre-amendment statute, that this is not subject to statutory interpretation, that we need to apply a supremacy of text principle to.
Sure, and I understand your statutory interpretation argument, just simply as like a procedural matter, right? The rule, the procedural rule 3.190, I believe it is, that talks about, the filing
Yes.
of a motion to dismiss that brings forth, a factual allegation that's sworn, and the state has an opportunity whether to contest that material fact. I mean, you would concede that we have to examine whether that fact is material. You don't automatically win just because the state has failed to rebut the fact of the outstanding fine and court costs, right? We still have to do the statutory interpretation work, right?
Correct, Your Honor. Yes, even if the state, which in this case, I would submit to the court that I'm sorry, I lost my train of thought, but that the traverse that was filed by the state, I would submit that it was insufficient in the fact that the state did not specifically address any of the material allegations or facts that were made in Mr. Ryan's.
The state appeared to contest materiality, but not the fact itself, right? So your motion says there are these outstanding, costs and an outstanding fine. The state in its traverse says, well, regardless, we still win because of our reading of the statute, right? At least that's my understanding of the setup here. So if you want to pivot and go ahead and talk about your interpretation of the statute and why you believe it's correct, we're happy to hear that, unless my colleagues have questions about the procedural aspect.
I do have a question about the procedural aspect, and I don't want to detain you too long. Let's put aside the traverse. Let's assume there was no traverse. You would agree with me, would you not, if an attachment contradicts the motion, that looking at the motion to dismiss in the light most favorable to the state, you would not be entitled to prevail? Hypothetically. I know that's not your position here, but if the attachment fundamentally contradicts the motion to dismiss, you would agree that's not something the court can grant?
I would agree, Your Honor, with that hypothetical. Of course, as you stated, I don't agree that that is what in fact happened in Mr. Ryan's case, but hypothetically speaking, if it did, yes, Your Honor, I would agree with that.
Well, let me ask you about Mr. Ryan's case. We have appended to this motion, and every reference to this fine talks about Exhibit B. Exhibit B, as you know, is the certification from the clerk saying this is a true and correct copy of the docket. But as the trial court pointed out, this true and correct copy is dated November 9, 2020. So if you look at that docket sheet in a light most favorable to the state, and the cases say we've got to look at it in a light most favorable to the state, doesn't that contradict the language of the motion to dismiss saying there is an existing fine, meaning there was a fine as of November 9, 2020, but how do we know there was a fine existing at the time of the hearing?
Well, I believe, Your Honor, in the actual motion to dismiss that was filed by Mr. Ryan, one of the factual allegations that was attested to was that there was still an outstanding $1,000 fine that was owed, and that's regardless of the registry that was attached to it. So
and that's my point, and thank you for that answer. But every time that's referenced in the motion, it says see Exhibit B. So the predicate for the statement is the registry. So isn't looking at this in a light most favorable to the state, don't we have to affirm what the trial court said, that we don't have evidence based on this exhibit that in fact on the date of the hearing this fine existed?
Well, Your Honor, the argument I would make to that is that even though that registry is dated 2020, that the motion to dismiss was filed in 2022. And I believe that based on, again, the factual allegations that were made in not just the registry itself, but the fact that the fine was still outstanding, I believe the factual allegations support the fact that even though it's dated 2022, that it's still a correct factual admission that he's making, that this reflects that in 2022 it was outstanding, and in my motion that I'm filing in 2022 it is still an outstanding fine. So that's how I read the registry and how I believe that and how they coincide.
And last question for me, and then you can go about the statute, and I'll get out of the way of Judge Pratt and Judge Makar. But assume, and I know it would be your position, it's not this case, but assume this Exhibit B doesn't show the fine. And I know that's not our situation, but let's assume see Exhibit B and the exhibit says nothing about the fine. Would you agree in that situation that it would be improper for the court to grant the motion to dismiss regardless of what was said in the motion to dismiss?
Well, the way that I understand when I read the rule, Your Honor, was that the factual allegations that are made in a motion to dismiss are, unless they're specifically objected to by the state, that those are deemed to be true and admitted. He swore to it, and that is in a paragraph of the motion to dismiss, that the $1,000 fine was still outstanding. So I believe that what he swore to constitutes sworn testimony.
Counsel, does the rule require proof, or does it require merely allegations supported by an oath?
The way I read it, Your Honor, if it's supported by an oath, then that is deemed to be an admitted fact on the part of the defendant.
So if we could get to the reading of the statute, the pre-2021, the applicable version of the statute, the parties briefing, neither of the parties seem to address what seems like it might be an important aspect of the statutory language, and that's the phrase released from. Does the phrase released from typically imply some sort of physical confinement or custody? Maybe another way of asking the question is, how can one be released from a fine or a cost?
Well, I think the release comes upon satisfaction of whatever that sanction might be. So in this case, my reading of the pre-amendment statute is that the sanction imposed can constitute any number of sanctions, which can be fines, probation, prison.
And the statute does define sanction, or at least list maybe an unexhaustive, list of things that constitute a sanction. But there's a curious part about that too, where it says for purposes of subparagraph I, not double I. And, you know, the operative provision of the statute that seems to be in dispute here is sub II, right? So, you know, are we to interpret that language, which says for purposes of subparagraph I, to mean that sanction means different things between those two subparagraphs? And if you think that it means the same thing in sub 2I, why does the statute not say that? Why does it specifically call out sub I? If you could help me with that.
Well, based on my reading of it, I see that the sanction being inclusive of any sanction imposed, regardless of what subsection you find it referred to in the statute. So I think.
But if it's regardless of subsection, why doesn't it say for purposes of this section? Right? It doesn't say for purposes of this section. It says for purposes of subparagraph I. That's very specific. I'm just wondering, you know, what your interpretation would have us do with that specificity.
Well, I would just go back to, again, my reading of the pre-amendment statute is that the language is clear, it's unambiguous. I just looking at the plain language in the statute. I just see the sanction referring to all the sanctions that are imposed, regardless of what subsection those sanctions may fall under. I think it's inclusive of all of them. Should I continue?
Sure. From my perspective. Sure.
There we go. I thought we had lost Judge Pratt, but he's back.
Okay. So as I began with my argument, I would respectfully submit to this court that it should rely on this supremacy of the text principle, which states that the words of the governing text are of paramount concern. What they convey in their context is what the text means. And I would point to, obviously, I would ask this court to adopt the opinions and the rationale. I think it's very clear. I think it's very well articulated in both the second DCA's opinions in State v. James and in State v. Crows that we are to apply the supremacy of the text principle and just look at the plain language of the statute. And if we do
Counsel,
that,
would it be fair to say that none of the second district's opinions, none of the panel opinions and the en banc opinion really addressed or maybe focused on the meaning of released from, you know, whether or not that connotes some sort of physical confinement or custody that someone is being set free from? Would it be fair to say that those opinions did not address that aspect of the statutory language?
yes, Your Honor, it would absolutely be fair to say that. I do not recall reading that in either of those opinions. They focused more on what the definition of the sanction meant as opposed to any sanction, and that the sanction means the entire sanction.
Sure. Would it also be fair to say that none of the second district's opinions focused on that other question that you and I were talking about a little while ago, the specificity with which the definitions applied, at least in the statutory language itself, where it talks about sub little I?
Yes, Your
It's
Honor.
distinct from sub 2I.
Yes, I would absolutely agree with that assessment. They did not address that issue.
Okay. And that's also not addressed in the parties' briefs in this case?
That is not I did not address that in my brief. I do not believe the state addressed, but I can't say for certain, but I can say that I did not address that in mine.
But I mean, overall, your argument is that under this statute, your client does not qualify as a sexual offender that's subject to the registration requirements. The state contests that and argues the opposite. It's our job to make sure that we're reading the statute correctly. So even if it's not specifically focused on in the parties' briefs, I mean, the language nonetheless is in the statute, and we need to take into account all of the statutory language when we resolve this appeal. Was that correct?
I agree with that assessment, Your Honor, absolutely.
Counsel, you said you, I think it may have frozen on the screen when we said this. You agree with Judge Lucas's en banc opinion. Is that correct? That's what you want us to adopt?
I do, Your Honor. That's the State v. Crows opinion.
Yeah. What's wrong,
Yes.
what's wrong with Judge LaRose's approach?
The Judge LaRose
Judge
being,
LaRose and 5 other judges said we don't need to go into just beyond what we've always done, which is look at the text and interpret it, and we don't need to get into all this other stuff that Judge Lucas went into, which was interesting. But what's wrong with Judge LaRose's?
I just think for simplicity's sake, I just believe that if we're going to follow, which I think is the correct analysis, which is the supremacy of the text analysis, that we simply focus on the words in the statute. We focus on the plain language that is used in the statute, and that we look that those terms and the words that are used are clear and unambiguous. And I believe that that's been the case. I believe that the Florida Supreme Court follows that same tenet.
Well,
that
yeah, but as I read it, Judge LaRose is saying that he's following the supremacy of the text principle. He's just saying we don't need to get into this question of whether we need to look at the subsequent statute and whether that was a clarification of the earlier statute. He's just saying, I'm looking at the previous statute and I read it the way the majority does. And I don't need to go any further. I don't need to go into this.
I mean, yeah, and for simplicity's sake, I absolutely agree that he is correct with that, and that would be my approach as well. I think because there were differing opinions with the second DCA, they had State v. James, and then they rescinded or they abrogated from that, and then they had State v. Hull, and then they went back with State v. Crows. I think they felt a need to elaborate further on the decisions that they had made, both past and present, to explain how they reached the ultimate conclusion that supremacy of text is the principle that should be applied. And again, that is just my theory on perhaps why they felt the need to go into such great detail regarding the post-amendment statute that was passed.
Yeah, but the certified question in that case goes beyond supremacy of the text. It says, can a court consider criminal statutes subsequent amendments to clarify a prior version of the criminal statute, consistent with the supremacy of the text concept? So they kind of went beyond. If your position is that the supremacy of the text principle decides this case in your favor, then you're really sort of in the LaRose camp. If you're in the Lucas camp, you're saying not only does the supremacy of the text principle apply, it wipes out this other concept that you can look at subsequent statutes to glean statutory meaning. I think the principle in this case is that you just want to look at the previous statute and it's clear and unambiguous. End of story. You win. Correct?
Yes.
Okay.
Yes, correct. Yes. That is our position. We absolutely believe that, the State v. Crows opinion, and even the concurring opinions for different reasoning, that that it was well articulated and that their rationale makes perfect sense.
Okay.
Can I reserve my last 3 minutes if possible, just for my concluding statement?
Well, we'll be glad to give. We took you over the 2, so I'll be glad to give you a full 5 minutes. And the other side gets additional 2.
Thank you.
Good morning, Your Honors. May it please the court. My name is Rajan Vasish on behalf of the state. I'd like to start addressing Judge Pratt's question about the release from language. And I agree with your inclination that release from seems to indicate some kind of confinement type of scope. But I think the reason that our briefs don't address it is because it runs into the same problems that the word the does. We find it still ambiguous at a surface level. It doesn't really help you define what the important word is here that both of our briefs focus on, which is the word sanction. The case today is about what the word sanction means. Now, Mr. Ryan pushes on this court a strained interpretation of the word sanction that allows sex offenders to delay registering as sex offenders until they've decided to pay their fine. And his entire argument rests on that preceding word, the, and I think similarly release from. That's one word in a statute of thousands. However, we know that words like the can have multiple meanings, as the Noel Canning case tells us. So I think it's just unhelpful clues as to what the problematic word, which is sanction, what that means. And
Mr. Vasish, before we get fully into the statutory interpretation question, just wanted to give you a chance to respond on the procedural aspect and what the rule requires. In your view, does Rule 3.190 require the defendant to offer proof of the facts that he asserts, or does it simply require an allegation supported by a sworn statement? That's question number 1.
Your Honor, we'd rather just leave the preservation procedural issue in the briefs and don't want to push that argument here today. I'm happy to just get to the merits and to just leave preservation and the procedural issue in the briefs.
Okay, but still, I mean, nonetheless, I'd like to hear an answer just on that particular question. Does it require proof, or is the defendant's initial burden satisfied by an allegation supported by a sworn statement?
I mean, the state's position is that you would need some kind of proof, as you were pointing out in your colloquy with the other side. But again, I'd rather just leave that procedural issue in the briefs.
Okay, and then the
Well,
last
well,
question
and-
is to see.
And I'm sorry, it's an important issue to Judge Jay. So I am going to ask you about that, and then you can get about the statutory analysis. I'm reading from State versus Paul. It's a 2020 5th DCA case. Judge Lambert, Judge Edwards, Judge Eisnagel. De novo, obviously, is our review, but it talks about what our analysis point is, and it says the state is entitled to the most favorable construction of the evidence. And all inferences arising from the facts contained in both the motion to dismiss and the traverse must be resolved in favor of the state and against the defendant. Is that a fair statement of the law?
Your Honor, we took a look at that case as well, and that's why I'd rather keep the preservation issue in the briefs. We agreed at second look that there might not be as strong of a basis to contest preservation, which is why I'd rather just get to the statutory issues.
Well, and I'm not talking about preservation. I'm just saying if the trial judge was right, read the transcript this morning, and there was a fact question based on the attachment, that's it, is it not?
I think you're right to point out that the trial judge could have found that there's a factual dispute and then deny the motion to dismiss, yes.
I mean, you are telling us today he was categorically wrong for doing that, are you?
That I think the judge was categorically wrong?
Right, correct.
No, I mean, I think the judge found that there was a factual dispute, as you point out, between the attachment and the statements in the motion to dismiss, denied the motion to dismiss, and use that fact to distinguish State versus James. I think they were right to do so, but as we took another look at it, we decided to rather keep that whole procedural issue in the briefs, and we're happy to move on to the merits on that.
And counsel, if you'll permit me one more question on that topic. Am I correct in understanding that it's the state's position that there's an affirmative conflict between the facts that the motion to dismiss alleged, namely that there's an outstanding fine and court costs, and the attachment, which says that as of a certain date, which was before the filing of a motion to dismiss, at that time, there were outstanding, I believe it was costs. So is it the state's position that there's an affirmative conflict between that attachment, what we're going to call the evidence, and between the allegation that's in the motion? Is that the state's position?
That's right, and I think that's what the judge found in the lower court, and that's why they denied the motion to dismiss, and then use that fact to distinguish State versus James.
Okay, but so how did, I guess, permit me one more question then. How is it conflict to say that, you know, today I owe these things, I owe this fine and these costs, and then to say, and here is an attachment that says a year ago or 2 years ago, I also owed that fine and those costs. Where's the conflict? They seem to be, you can easily reconcile them, can't you? Right? To say I owed something 2 years ago and I owe it today, those are not internally inconsistent, right?
I misunderstood your question, Your Honor. Yes, I see your point now. Yeah, I think that's a procedural issue, again, that we'd rather just not argue today at oral argument and rather just leave that in the briefs.
Okay.
Like I said, we took a second look at it. We realized there was less of a basis for like this whole procedural factual preservation issue than we thought initially, which is why we'd rather just move to the merits.
Fair enough. Fair enough. So let's go to the statute.
And thank you. And one more question, and I'm sorry, Judge Pratt, but setting aside preservation, if there was, and I know Judge Pratt may have a different view of the world than Judge Jay, but if there was a conflict between the attachment and what was said in the motion, you would agree that would be a reason to deny the motion to dismiss, would you not?
Yes, Your Honor, if there was a conflict, but I take Judge Pratt's point that there potentially with the way it was worded, the attachment versus the motion to dismiss, there was a way to reconcile them. But I agree, if there had been a conflict, I think that'd be a fair basis for a court to deny the motion to dismiss.
Okay, well, and I am going to have to ask one more question. So you say something categorically in the motion to dismiss, and the attachment contradicts it. In that scenario, the court would be correct in denying the motion. Looking at it in a light most favorable to the state, correct?
In that hypothetical, yes.
Okay.
So on the meaning of the statute, counsel, I feel like I should afford you an opportunity to engage with the questions that I posed to your friend on the other side. That statutory language released from, right, combined with the fact that the definition of sanction is limited for purposes of sub paragraph, little I, single I.
Yes.
Can you help us to understand what we are to glean from that particular language in the statute?
Yeah, so I'll start with the subsection I. I agree that it's a weirdly worded part because the word sanction isn't in subsection I. So I don't think it really limits any particular word in subsection I. What I think was happening was it just listed out, here are the relevant punishments when we're talking about these predicate offenses that we care about your release from in the second section. So it's saying, for the purposes of these predicate offenses, here is our list of sanctions that we are considering when we're considering what you have been released from. I think that's the best way to square it, considering subsection I doesn't actually use the word sanction itself. And the release from language, I agree with your inclination that naturally it seems to kind of connote some kind of confinement. But I will spot the other side that I think there's at least a surface level ambiguity still because of the word that the word sanction is what we're really looking for here. And that because there's an ambiguity as to what release from and what the word is, they're just not very helpful in figuring out what sanctions. Now, the second sentence that you pointed out, this list of potential punishments, I think does a lot of work because it lists out a bunch of individual punishments and limits the scope of the word sanction. And so through the presumption of consistent usage, we can just assume that the legislature, when it used the word sanction in the previous sentence, kept that same limited scope. If they had wanted to use those two different uses of sanction completely separately, one to mean individual.
So just to help us understand like what this looks like in the real world, let's say hypothetically we have a defendant who was sentenced not to incarceration or probation or community control, but only to a fine and court costs, and otherwise, meets the definition for the conviction for sexual offender qualification here. So in that instance, right? So the defendant has never been sentenced to any period of incarceration or supervision. In that scenario, would it be the state's position that if there are unpaid costs and fines, that defendant is not yet considered a sexual offender subject to registration requirements?
They would qualify as a sexual offender the moment that they've been released from one of those pieces, one of those sanctions as part of their sentence.
In my hypothetical, though, there's still something outstanding on all of them, right? Maybe they paid 50% of the fine so far, and they've paid 50% of the court costs so far, but the other half remains to be paid. Under the state's position, that defendant is not required to register, right?
That's right, under this statute, but there are other statutes that could apply. So there's 944-606, which is about what the Department of Corrections has to, kind of information they have to give on potential sex offenders who have committed predicate offenses, and 607, which is different requirements on the clerk of the court where somebody got a sentence. Okay. It's on defendants.
So let's modify the hypo then, okay? The sentence is not just fines and court costs, but also a period of incarceration. The defendant is then released, let's say it's 2 years, released from his 2-year sentence of imprisonment, but still owes the fine and the court costs. In that scenario, the state's position is the person is subject to registration because the person has completed the incarceratory part of the sentence. Yes?
That's right. That's right, Your Honor.
Okay. So, okay. That helps me to understand your position. I appreciate that.
Right. So because the incarceration is one of the sanctions listed in that second sentence. And in that first sentence, when they say release from the sanction, we just think that the legislature meant release from one portion of your larger sentence.
Okay. Let's change the hypo. Okay. The defendant has paid all of the fine and court costs, but remains incarcerated. Is the defendant subject to registration requirements?
The defendant would then count as a sex offender for the purpose of the statute, but the registration requirements wouldn't have kicked in yet. So you couldn't be subject to any criminal liability. Well, they wouldn't have had to register.
Why?
Their registration requirements kick in after being released from the incarceration. So,
but wait, no. I thought it was released from any part of the sentence. So if the sentence is, or the sanction, excuse me, and if the sanction is imprisonment plus fines plus court costs, and if being released from a fine or a court cost means simply having paid it, if the defendant remains incarcerated but somehow has found some way to pay in full the court costs and the fine, then the defendant has been released from the court costs and the fine under your reading. Is that correct?
Let me clarify what I said a moment ago on that hypothetical. What I meant was that they would qualify as a sexual offender under the definition of the statute but they wouldn't be subject to the registration requirements yet, because they'd have to have been released from incarceration period first. So that's what I meant when I answered your first hypothetical.
Oh, and that's in a different part of the statute dealing with the registration requirement itself?
Yeah, so there's subsection 2 of the statute tells you when you have to register, and that's separate from the definition of sex offender, which is what we're disputing here. When I've answered your hypotheticals, I was under the assumption we were talking about the definition of sex offender. That's what I meant by subject to the statute.
I see. Okay.
And so again, we think that that second sentence really is doing a lot of work here. But even if it wasn't, section 12 lays out the explicit purposes of this statute. And it says that we want to protect the public from people who have committed the predicate offenses and have been released. This is from the statute, released from incarceration and are back in the public. And this court has held in State versus Mounts that section 12 is meant to be a gap filler and ensure that there are no registration gaps. Here, our interpretation is the only one that kind of aligns all of that. Under the Mr. Ryan's reading, it would allow for a gap period, and Mr. Ryan's a perfect example of this, where you can be released from your incarceration and be out in the public and not have registered and continue to delay paying your fine until the final due date, but you're out in the public. And section 12 says that they want to prevent that, and that's explicit in the statute. So I think it's proper for a court to read what could be an ambiguous phrase through the lens of section 12, which is an explicit purpose. And this court has already done that in State versus Mounts. So I think that's a very key piece of evidence as well. Now, another data point on the consistent use argument that we make is section 11. Section 11 outlines how an offender can be released from the requirements to register as an offender. And the first factor asks whether the defendant had been released from confinement, supervision, or sanction, whichever is later. Under Mr. Ryan's reading, if the word sanction is the same as the word sentence, that phrase is superfluous because sentence would always end later than confinement and supervision. One couldn't end later than the other. Ours is the only reading that allows for sanction to potentially end earlier than your confinement or your supervision. So again, as presumption of consistent usage, that limited scope should be applied up to our definitional statute.
So why wouldn't a fine be a sanction?
Sorry again. Sorry.
Why would a fine not be a sanction?
Well, I think a fine would be a sanction. I think it'd be one of the listed punishments defined in the definitional part of the statute. Our argument as to section 11 would be that you could finish your fine first, finish your confinement and supervision later, and that provision in subsection 11 would have meaning. But if Mr. Ryan is correct that the word sanction means the entirety of your sentence, then there's no possible way for your confinement or your supervision to end any later than your sanction under their reading, which has to be contemplated by that text, which says whichever is later. That provision would be superfluous. Those words would not have meaning.
Am I being too simplistic in saying the state's position that being released from the sanction, and this is essentially means released from incarceration? That's the long and short of it.
No, Your Honor. Our argument is that release from the sanction means release from any individual punishment listed in that second sentence. That all of those count as a sanction. When it says release from the sanction, it just means any one of those in its own definitional section of the statute. I mean, it tells you right there, here's what all of the sanctions are. We think when it says release from the sanction, it's just referring to that list. That's the relevant list that counts for what we're considering to be released from. It's not just incarceration, even though that is on the list.
Okay, so rather than release from all the sanctions, release from any one.
Exactly. Mr. Ryan puts forward a reading of sanction that's a collection of sanctions, which I think just doesn't make sense considering not only like the natural reading of the word sanction, but just how the text uses the word sanction in different areas of the statute itself. I think it implies or kind of seems to adhere some kind of limited scope, and that just can't square with their reading.
Thank you.
The other thing I'd like to point out, Your Honor, is that in 2016, the legislature reenacted this exact definition, this exact part of the statute and the disputed language. They passed it again. The same language released from the sanction was part of a bill in 2016 amending other parts of the statute. And that just comes in a long line of amendments that the legislature passed between 1997 and 2016. And so when they reenacted the language, we argue that they were subsuming a lot of gloss that not only FDLE, but other lower courts had used as well in understanding our disputed provision to be read the way the state argues, that release from the sanction just means release from a sanction, kind of natural reading.
I'm sorry to interrupt. Could I ask one clarifying question? Maybe I'm misreading Crouse, but I thought in Crouse they said that because the probationary period was still in place, or was the probation, I guess. There's other, the approach you're suggesting, the state's position, is in conflict with Crow's, Judge Lucas's position, correct?
You're saying from the Crow's opinion that the state and Crow's was in conflict with what they decided?
Yeah, the position that you're advocating today, that release from any sanction is enough. And in Crow's, it seemed like this gentleman had not been released from the sanction of, I think it was some type of probationary period or something.
That's not in conflict with what we're saying today, because as per the original statute, probation was one of the listed sanctions in the definition section, that subsection 2. So the fact that probation was still outstanding still qualifies as what we're saying, that because one is outstanding doesn't mean that you haven't been released from any sanction. I think in Crow's case, I think it was the same here, where he had been released from incarceration, if I'm remembering correctly. Since he hadn't been released from the entirety of the sentence, Mr. Crow's argued that he hadn't been released from the sanction as required by the statute, whereas here, we're only arguing that you have to be released from one of those individual sanctions listed in the definitional section.
But I thought in Crow's it says defendant who is still completing probationary portion of his criminal sanction was not a, quote, sexual offender, end quote, under the operative pre-amendment version of the statute. So they upheld the trial judge who granted the defendant's motion.
And the defendant in Crow's had completed his incarceration, right?
Exactly right. So
One of the sanctions, right? He had completed a sanction. So
That's
under
exactly
your
right,
reading, right?
That's
How do
exactly
you
right.
reconcile your reading of Crow's?
I think here the fine is parallel to the probation in Crow's, where there is still one piece that was outstanding, and the incarceration period had ended for both Mr. Ryan and Mr. Crow's. But here the fine is outstanding. In that case, the probation was outstanding. So I think that squares that the position is the same in both. It's just that you have to be released from one portion of it. In that case, it was the incarceration. Hope that answers your question. But regardless, in 2016, that's the provision of the statute that would have been operative on Mr. Ryan in 2018 when he failed to renew his address at the DMV. The 2016, like I said, reenactment included all this language and subsumed a lot of gloss about how FDLE and other courts were using the language, and they didn't feel the need to change it. And in fact, in all of their amendments from 1997 to 2016, they never felt the need to change the language. It was only in 2020, after the State versus James opinion, that they felt the need to come in and eliminate moving forward any kind of superficial ambiguity as to the original phrase. But in 2016, it subsumed a lot of gloss. I think that's a really important evidential point as to what the word sanction meant, not only to longstanding practice, but to the legislature in 2016. That would be the relevant statute that applied to Mr. Ryan here. And the meaning that we're trying to determine here is not the one from 1997, it's the one from 2016.
So under the Florida Supreme Court's approach to statutory interpretation, do we ask what a later legislature thought that an earlier legislature meant by the words that it used? Or instead, do we ask, what do we as judges think that the words that they used meant, the ordinary meaning that they carried at the time that they were enacted? And aren't those two things different?
Yes, you're right. It would be the second one, Your Honor. Our only argument as to the 2021 amendment is that it's a piece of evidence for you to use when you, as a court, determine what the 2016 statute meant when they wrote release from the sanction. And here, the legislature was very clear what they said. They're saying their interpretation of that statute was not what State versus James held. It's that release from a sanction, release from the sanction means release from any one of those individual punishments. And so again, we don't argue that that's binding on this court. We don't argue that it was binding on Mr. Ryan. We only argue it's a piece of persuasive evidence. It still exists in Florida Supreme Court case law that courts have a right and a duty to consider legislative amendments. But obviously that couldn't be binding on Mr. Ryan without some kind of ex post facto problem. And it couldn't be binding on this court, like you said, without running into supremacy of the text problems. It's just a piece of evidence, kind of like if the legislature wrote an amicus brief and said, here's what we think the correct answer is. It's something for the court to consider. It's not something that the court has to use.
I thought the en banc court in Crouse basically said we can't do that. We have to look at the original statute and the subsequent statute. We have to put on blinders.
I think what the whole majority and then the Crow's en banc majority responded to was a much stronger version of what they thought the recent controversy rule was. It seemed that they felt that the recent controversy rule was going to bind them as to some interpretation. And again, we're not arguing that you're bound by the amendment. And in fact, we don't need the amendment to win. We just think it's confirming evidence of what we can already point to in the statute through all of the other pieces of contextual evidence just shows that the legislature agrees with us that the word sanction has a narrower scope than the entirety of the word sentence. And so I think just responding to the point on Crows, Crows lays out in great depth what could be wrong with a version of the recent controversy rule that binds not only Mr. Ryan, but courts. But we just don't put forward that type of use of the recent controversy rule here today. We put forth one that's consistent with both recent controversy rule cases and with the recent supremacy of the text cases like Ham and Laboratory Court. And so I just want to conclude, Your Honors, the reading pushed by Mr. Ryan would leave a gap in the statute. That just cannot make sense with Section 12. The gap in the statute would be that somebody who's released from incarceration can delay on their sentence. Your Honors, if I could have a few minutes of grace to finish my sentence.
Just take a few moments to finish up, please. Thank you.
Great. Yep. Allows them to delay from finishing off their sentence in order to avoid registration requirements. And State versus Mounts tells us that Section 12 doesn't allow that. And for these reasons, we ask this court to affirm.
Thank you, counsel.
Your Honors, it is Mr. Ryan's position that based on the clear and unambiguous language in the operative pre-amendment version of 9430435, that he was not required to register as a sex offender at the time of his alleged offense, as he had not been released from the entire sanction imposed in his underlying case at the time of his arrest. We believe that his position is supported by the second DCA's opinions in State v. James and in State v. Crows, which we would ask this court to adopt. I would also make the argument, Your Honors, that with respect to, if the court doesn't agree that the supremacy of the text principle should be applied, which of course we do assert that it should, with respect to the rule of lenity, it states that when the language in a statute is susceptible to differing constructions, it shall be construed most favorably to the accused. So as far as that rule is concerned, even if we were to accept the state's argument that the sanction is a generic phrase that refers to any sanction, it's Mr. Ryan's argument that the phrase the sanction applies to his entire sanction. Although Mr. Ryan does not agree that the language in that section is susceptible to differing constructions, even if it was, our position is the rule of lenity would apply and the most favorable construction of the statute should be applied to Mr. Ryan. And I would just point out, I have a quote from State v. Crows where they found that fifth and finally, if we were inclined to accept the state's construction of the sanction imposed, it would at most amount to a valid competing interpretation of the statute's text. We would then find ourselves with a run-of-the-mill ambiguity regarding particular applications of a criminal statute. And the rule of lenity would compel us to follow James as the more lenient application, which is also what we're asking the court to do with Mr. Ryan's case, is if you're going to apply the rule of lenity, it should be applied most favorably to him. And in conclusion, Mr. Ryan respectfully asks of this court to reverse the trial court's denial of his motion to dismiss and to remand his case with instructions for the trial court to dismiss the criminal charges against him. Thank you.
Okay. Any other questions from the panel? All right. Well, I want to thank again both of you for accommodating us and having this oral argument. It's been very, very helpful. And we will have the case under submission. So we'll be in a journey. Thank you.
Thank you.
Thank you.